FIR is not admissible in the evidence, especially directly it is not. And that is why the informant again has to come to the court to tell and depose everything that he has mentioned in the FIR. Now, what is FIR then? FIR has not been defined in CRPC, it is not defined in IPC, and in any of the laws. The definition of FIR has not been given by the legislative body. FIR is just the first information given by any informant to the police in charge of a police station. Sometimes it is SHO, sometimes it is station officer, SO, but any information is not FIR. That means the FIR which pertains to the commission of a cognizable offense. So here two words have come. The cognizable offense. You need to understand the meaning of offense as well as cognizable. Offense as per section 2N of CRPC, any act or something which is punishable by law. So if you do something or you don't do something and there is a punishment associated with it, that makes it an offense. What is cognizable offense? Cognizable offense or the cognizable case. The proper definition is not there, but the implication of registration of a cognizable offense is given. It means an offense or a case wherein the police officer can arrest the accused without warrant. It is a situation basically. So the definition of cognizable, non-cognizable offenses, that is again, the definition is not given, but the classification of the offenses, which offense would be cognizable, which would not be cognizable offense, that is given. But the exact definition is not there. So section 154(1) says that police officer is bound to register the information in case it pertains to the commission of a cognizable offense. Section 154(2) says the copy of this FIR has to be given to the complainant free of cost. And section 154(3) says if the police officer does not register the FIR, then the informant can approach the senior police officers in the same manner through speed post, and he can also file the same information before the senior police officers. And the senior police officers have right to get it registered as the FIR. He can direct the station house SHO to register the FIR in these kind of cases. Now, Supreme Court has already stated in Lalita Kumari versus UP that in case the police officer receives the information pertaining to the cognizable offense and he does not register the FIR, then the action can be taken against that police officer under section 166A of IPC. However, practically it is not implemented to that extent because most of the state police bodies, they are, overburdened, they are under deployed, and the state government does not recruit as many police officers as they should. So there are lots and lots of vacancies in every state related to the the police services. Now you would ask, what is the importance of FIR then? The FIR is basically the earliest information that reaches the police. It is the information which activates the criminal law. So as soon as this information reaches the police officer, the criminal law gets activated. Now, after the registration of the FIR, the police officer gets the authority to investigate the commission of the offense and try to collect the evidences to understand and to know who has committed this offense. So the entire set of investigation revolves around the fact that these are the evidences and the person who has committed the offense should be brought to justice, investigated accordingly. And once the police officers identify, the investigating officer identifies that person, the charge sheet is filed after thorough investigation against that person.